Hi guys, it's Kathy. I hope you're doing well. Hello again to those who were just here a couple hours ago. Get to sleep. Did you not sleep because you're a little itchy? I was a little itchy all night long. Just a little itchy while I'm sitting here working. I keep looking at the ceiling. I added something to my TikTok shop cart for the first time. Never used TikTok shop before, but I added this mattress steamer. I can't wait. I didn't buy it yet. I added it to my cart. That's step one. So we have today we have a defense attorney who brings receipts. I mean, she is about as prepared as I have ever seen. She has a solid plan, and that's usually all judges want. It's a solid plan of how to move forward. Then the prosecution talks. Wait till you hear what the prosecution has to say. You got to get through the defense attorney first, and she does an excellent job. Here we go.
That sound right?
Yes, that's
Yep.
my understanding.
Okay, so this sentence on both these everything will be concurrent. Counts 3 and 4, and then concurrent to Adams 25 CR 2528. Now, I do need you to report to probation today, though, here in Denver.
Yes, ma'am.
Um,
Yeah, I'll go right.
So make sure you go over there before you leave here today.
Yes, ma'am.
Anything else?
Just the end of deferred judgment,
Oh,
date, Your
right.
Honor.
Thank you. End of deferred judgment date will be February 3rd, 2028. You'll need to be back here in court unless you get an order saying otherwise. Ms. Sheik.
One final thing. There was never and now the words are escaping me. He was never given permission to go and get his belongings with a civil assist. Would it be possible for a civil assist to be authorized? He has indicated it should be very quick. He thinks he has 2 boxes of belongings at the victim's home. He indicated that the victim's aunt has tried contacting him, but he's never answered the phone because he was afraid it would be
A violation.
a violation of the protection order.
Mr. Bassiano, any reason
I-
if there's never has been a civil
Right.
assist?
I do think that he would be entitled is probably not the right term, but I do think that would be an appropriate thing for the court to authorize. This was a situation where this case was upfiled by from a misdemeanor case. I just was going to confirm if that there had not been a protection order entered in the misdemeanor originally that authorized the civil assist, just to make sure that everything is
Well, and we do
accurate.
actually, I suppose, need to look at the protection order that was issued in this case. It was issued October 24th. It lists Ms. Berg as the one victim.
Yes, and it does.
So my understanding is that this protection order remains appropriate as it is currently drafted. And that even with that, even with this original protective order, I can still authorize a civil assist.
Yes,
Okay.
and I do believe that is correct, Your Honor. I did just check. The misdemeanor protection order that entered did not actually have a authorized civil assist. So I do think there's not been a civil assist ever authorized that I can see. I think that the court could authorize a civil assist in this manner, in this case. Obviously, that would be something that Mr. Campbell will need to coordinate with the sheriffs for executing that civil assist. And abide by all the terms. If there becomes any issues, I would just ask that he speak to his attorney and Ms. She can reach out to me and we can, but I don't anticipate that being any
Right.
issue. They do
Okay.
that on
The
a
court
regular.
will authorize one civil assist, but with communications through the deputies.
Absolutely.
All right.
Thank you.
All right. Thank you.
Thank you, Your Honor.
All right. Next.
Yes, Your Honor, we're ready on Mr. Johnson's matter. It's number 26 on the docket.
I do apologize for I didn't clip that last little bit. I must have missed it, but it's fine. This is the one we want to see.
Court calls number 26 on the docket, People versus Quincy Johnson, 25 CR 3463. Entries.
Holly McDonald for the people.
And Emily Boehm on behalf of Mr. Johnson. He is present next to me at the podium appearing in custody.
Is it Boehm?
Yes.
All right, we are set for our first arraignment in this matter. What do we need to address?
Your Honor, we are asking for a continuation of the arraignment. I have a forensic social worker that I am working with to prepare a mitigation report. There are a significant amount of collateral documents, some of which we have, some of which we are waiting on. So I did let Ms. McDonald know that our request would be a continued arraignment, and she, I don't believe, is objecting to that. In addition to that, we are asking to address the issue of bond today.
And I also just want to jump ahead for a minute. Mr. Johnson was 18 at the time of the charged offenses, correct?
He was.
Okay, so we don't need to do a reverse transfer to address reverse transfer at all, right?
That's correct.
Okay, all right. People, can you address bond today?
Yes, Your Honor, we are in VRA compliance.
All right.
Your Honor, would the court like me to start there
Yes,
with
please.
bond? May I approach with a release plan that was put together by my forensic social worker?
The
I
people
did
have seen
provide
it.
them a copy.
You may.
Thank you.
Yes, she has a forensic social worker. Again, we get the forensic social worker and a thorough release plan.
All right, you may begin.
Thank you, Your Honor. So Mr. Johnson was an out-of-county advisement, and I think that the pretrial bond report that was filed in this case is lacking information that would be helpful to the court's determination in setting a bond. And that was the information that was available to the initial court when they set the bond in this case. I did provide a release plan to the court, which I think addresses a number of things that the bond statute asks the court to consider. Mr. Johnson was accepted into sober living at 2 locations, Ononeo and Stride. I do have letters from both of those locations indicating he was accepted and would be able to go to a bed there, and I can file those as exhibits to this hearing today. In terms of a release plan in either of those situations, Mr. Johnson would be released directly from the jail to staff at one of those sober living programs. He would have a strict 9 p.m. curfew. He would be required to take classes weekly. And certainly he is willing to wear a GPS monitor and comply with any other conditions of bond that the court feels may be appropriate. In addition, at both of those locations, there is staff on hand to monitor Mr. Johnson on a continuing basis. If and when sober living said it was appropriate, he also does have job options available to him as well. One of those job options would be working with his aunt. Her name is Roxanne Webster. She is present in the courtroom today. She is a manager at a location called Copper Nut and Bolt, and Mr. Johnson would have a job opportunity there 40 hours a week. I think the typical hours are 7 a.m. through 4 p.m. Monday through Friday, although the job often involves overtime. As the court can see from the release plan that was provided to the court, Mr. Johnson does have a solid support system, many of which are present behind me in the courtroom. These individuals include Len Chacon, who works with individuals in the jail and would be able to provide peer support. He is here today. The defense forensic social worker, Ms. Tenuta, who is also present today. his aunt who is present behind me, his sister who is present behind me, and in addition to that, Miss Woods, who is the restorative justice coordinator at Smoky Hills High, who is also
Holy
present
cow.
here behind me in the courtroom today. His sister is 24 years old. She stages homes for real estate agents and also works for a makeup company. If and when he were to transition from sober living to a different living environment, he would be going to live with his sister in a home that she recently purchased. His sister has no criminal history, is employed, and is positively involved in the community. I would note for the court that any of those individuals I referenced, again, are present here in the courtroom today and would be happy to answer any of the court's questions or address any of the court's concern. He does have additional ties to the community as well. His grandparents on both sides do live in the area along with his stepdad. Mr. Johnson has been thinking about his future. He wants to have a career that involves working on cars. He was supposed to go to trade school starting in August for collision repair, but unfortunately was arrested before he could make that happen. He, as I mentioned, is willing to comply with any conditions of bond. His plan is to go work and come home. He will do GPS, sobriety monitoring, whatever the court thinks is appropriate. I would also just draw the court's attention to Mr. Johnson's young age. He turned 21 recently while he was in custody, and specifically the considerations for the court in terms of the bond statute, namely 164103. As someone who recently graduated from high school and is still becoming a young adult, he clearly does not have the means to post $1 million cash-only bond, which is, in this case, for all intents and purposes, a no bond for him, as evidenced by the fact that the case has been pending for over 6 months and he has not been able to post that bond, even with the assistance of family. The other thing in terms of the bond statute and those considerations is the purpose in ensuring one comes to court. This case was initially filed in Arapahoe as a 2023 case and was ultimately dismissed there due to a lack of evidence. Mr. Johnson has been in the metro area the entire time. He attended every single court date in that Arapahoe case, and he was on GPS and maintained compliance with that GPS court order in that Arapahoe case, and again, remained in the metro area after it was dismissed. The
You're
other
supposed to go to
primary
court.
issue is that he, while in jail because of the bond amount, is on some of the strictest protocols. He is in his cell 22 hours a day and out 2 hours a day. Sometimes he indicated that that is more like 23 and 1. Certainly this has been challenging for Mr. Johnson as it
Yo, I don't feel bad for him one bit.
leads to isolation for hours upon hours every single day for months on end, which takes a toll in terms of anyone's mental health. In terms of the other considerations for the court and ensuring community safety, I think the release plan provided to the court is significant because it's comprehensive, but I think it also demonstrates Mr. Johnson's own initiative regarding a plan for his future. He has engaged with the MAT program while he's been in custody. He has engaged with individuals who work with the jail to provide resources and peer support. And certainly he has a number of individuals here in this courtroom who are pro-social, positive role models for him. But at this point, Your Honor, the most he would be able to afford, he believes, is somewhere in the vicinity of $200,000 to $300,000 cash or surety. What I can tell the court is any reduction would be significant in terms of his ability to be in a different pod or status level in the jail so that he is not in confinement for the vast majority of the day. And that is what I have for the court, unless the court has specific questions for me or the other individuals who are here to support him.
Thank you.
Was that not well done? She did a really good job. It's all worthless though.
For the people.
Yes, Your Honor. The people object to any change in bond. The people find the bond as is set as appropriate. In looking at the case and specifically Mr. Johnson's case, these are very violent cases. They are very concerning cases. If you look at Mr. Johnson's, the arrest warrant that went through, he is charged with 2 counts of, multiple counts, but specifically with 2 incidences. both taking place at 18772 East Union Place, within the matter of days of each other. At the time he was 18, and the first time that this house was fired upon on May 3rd, 2023, there were 5 individuals in that home: a mother, her daughter, another child, and then her 2 grandchildren. At the time that Mr. Johnson fired on this home, there was a 4-year-old and a 5-year-old that had to dodge bullets and hide. And in looking at the report, it lists the damages that was done. And if I can just have a moment. On the May 3rd incident, 1 bullet entered the east side of the kitchen living room window. That bullet traveled through the kitchen into a bedroom on the north side of the residence. 1 bullet entered the dining room under the window and impacted a white duck grill. 1 bullet projectile entered the upstairs master bedroom on the southeast side of the residence. This bullet traveled to the west through the bedroom and through the walls separating the bedroom and the bathroom. And it ended up striking and breaking a tile in the bathroom. 1 bullet entered the bedroom on the west side of the bathroom, where it entered a mattress in that bedroom. When that incident failed to, I guess, hurt anyone, kill anyone, failed to send the appropriate message, 4 days later, Mr. Johnson went back to the bedroom, or back to that house, and fired on that house once more. Again, in the report, there's 2 suspected bullet projectiles through the outer window of the kitchen, although they did not break the inner window. 2 suspected bullet holes along the north wall of the dining room. 1 suspected bullet projectile hole entered the south lower side of the door. 3 suspected bullet holes are on the south wall of the upstairs bedroom. The family indicated that 1 was from the previous incident. 1 suspected bullet hole in the window along the east wall that appeared to travel through the window blinds, curtains before striking the south wall of a bedroom. That was the interior. The exterior: 2 suspected bullet holes to the rear exterior of the resident. 2 suspected bullet holes in the window near the northeast corner. 1 suspected bullet hole in the window that led through the kitchen area. 1 suspected bullet hole to the lower south portion of the back door.
Every once in a while, she looks over at him while she's reading this.
2 suspected bullet holes in the window of the back door in the frame. 1 suspected bullet hole between the windows that they were not able to retrieve. The family in this matter lived through this, Mr. Johnson's actions, within 4 days. The amount of bullets that were fired is astounding. The people have grave concerns about the community safety, grave concerns about Mr. Johnson's ability to remain law-abiding. And quite frankly, the people was given this today in court. The people have not had a time to review or follow up on any of these sober living. I will note that this is the first time I'm hearing that sobriety is an issue for Mr. Johnson. As for stride, in looking at this,
How did he not hit anyone? Can you believe that?
he will have a strict 9 p.m. curfew. However, Mr. Johnson is an adult. He does not have to remain at a sober living. They cannot hold him. There's nothing about this being a lockdown facility, nothing about his ability to leave when he wants to. I understand that he has community and family support, but he had that family support when this occurred. And he still committed these crimes.
Chinny, is that you who said that just a minute ago?
This community safety plan or release does not indicate which sober living he will be attending. And again, the people would have appreciated a little bit more information that beforehand so that they could have followed up on these community safety, this community safety plan. Additionally, I would note, the victims do object. Miss Wright, the mother, whose home was shot twice in the two incidences involving Mr. Johnson, but a third time in September later that year, says she very much objects to the bond reduced. The defendant shot her house twice, and she and her family had to duck and hide from bullets. And that we can imagine how scary that was. Another victim that was in the home at the time indicates that she objects to the bond being lowered. She's scared if he was to be out. She believed people were following her, and she's just generally scared of the defendant. Reduction in this bond in this case is not appropriate. Mr. Johnson has shown a disregard for the safety of the community, the safety for the people of Denver, and particularly the safety of this victim, where he went back twice within a matter of days.
They never say why. They never say what the victim did or who the intended target was.
And fired multiple bullets into that home, given that the people would object to any change.
The court has considered the information provided by counsel and the release plan. The court has also reviewed the affidavit and application for arrest warrant for Mr. Johnson. Certainly, while these remain just allegations, the court does note that Mr. Johnson is facing 55 charges. In this case, the court also has considered the significant public safety issues that exist regarding Mr. Johnson's alleged activities. And frankly, the bond does appear appropriately set at this time. So the court is going to deny the request to reduce bond. Bond will remain at $1 million cash only. The court does, again, have really overwhelming community safety concerns. All right.
I think we just
There
need
you
an
go,
next court
Monica.
date, Judge.
How far out would you like to set?
Approximately 45 days if we could. I was looking at the April 2nd date.
I can do April 2nd.
That works for the people.
All right, the court will set this for arraignment on April 2nd at 8:30 a.m. Anything else?
Not from the defense.
All right, thank you. Thank you.
He's gonna come see you.
How are we supposed to talk to people if we're not on dating apps? You want us to
This
go
Mr.
out to
Oh,
the
we need
bar?
to call Mr. Naru's case. Did we just lose Mr. McCarthy? Or maybe I thought Mr. Drake's gray pants were Mr. McCarthy's gray pants. So we have the Chucky's interpreter case that we need to try to call and get reset. If you can message him, Ms. Landry. Can we take a quick matter before I get Mr. McCarthy back in?
Mine's a sentencing, so
Does anyone have a quick matter? All right, Mr. Drake,
Number 7, Judge, Pennsylvania.
the court calls,
I'm making myself dizzy.
isn't she in custody, Mr. Drake?
She is in custody and she's refused.
Oh, okay. All right. So the court calls number 7 on the docket, People versus Mariah Pennsylvania, 22 CR 4213 entries.
Kristen Lilly for the people.
And George Drake for Miss Pennsylvania.
All right, we are set for an appearance on an arrest warrant. Mr. Drake, you have been appointed as ADC. did you receive information from the sheriff's deputy that this is a refusal?
I did, yes.
All right, so would you like me to reset this? I can reset this for well, I can reset for tomorrow or I can reset for the 19th. At this point, those are my two options.
I'm here tomorrow, but I'm in another courtroom as well. That would be fine.
Do we have any idea if
If-
tomorrow's going to be a better day for her?
No, I mean, maybe 2 weeks out.
The problem is, well, I mean, I guess someone else will cover. I could do, I guess, February 26th.
That works.
26 or
26?
27?
26,
That's good.
okay. All right, we'll set for February 26th at 8:30 a.m.
Thanks, Judge.
for appearance on arrest warrant. Yeah. Ms. Scott, we're going to call Mr. Naru's case. The court calls number 38 on the dock.
I don't know. So there's two options. There's other options, but there's two options. I think the house got shut up 3 times. They only talked about 2 here. Now he has 56 charges, and they didn't talk about all 56 charges here. So it could have been him in a different case that they're charging him something different. Hopefully not murder. Hopefully. I don't think so, because they would have said that. They would have said, you know, he has a bigger bond in this other case, so you can drop this one, so it doesn't want to matter. Another option is he has someone else now shooting up the house for him because he's incarcerated, which is more terrifying.
Get People versus Alberto Naruo, 24 CR 2251 entries.
Kristen Lilly for the people.
Sean McCarthy on behalf of Ms. Naru, who is in custody and does not appear.
All right, my understanding is that for some reason he wasn't on the deputy's transport list, so we just simply didn't get him today, which is unfortunate because I know how tortured scheduling in this case has been. And I think a lot of the trouble with scheduling has come down to our interpreter availability. And so, Ms. Scott, I'm actually going to start with you, if that's okay. Do you have any dates that you know you are available? Thursdays and Fridays usually.
Your Honor, are you speaking to the interpreter right now?
Yes.
Okay, yes, my name is Miss Short, and that's why I'm sorry, I
Short.
was confused. Okay.
sorry.
Now, I'm sorry, you're asking availability for
Yeah, we need to reschedule this disposition hearing.
yes.
And I know your schedule is a limiting factor.
Yes.
Yep. I'll start with
Okay.
tomorrow. Is there any
Okay.
chance that we have tomorrow available?
Absolutely, no, I'm not available tomorrow. If I look into and what day of the
Does anybody have any idea what country a shoe keys interpreter is interpreting for?
week did you say?
Well, we usually do Thursdays and Fridays.
Okay. Let me look at the 19th. I do have some availability on the 19th. Sorry, I have to do all the zone difference calculations too.
Yep.
4:30. How late in the afternoon can you go?
Late.
Actually, what about something like 10:30 on that day? in the morning?
Defense counsel will be here.
This is Ms. Robinson's case, and I don't have bad dates for her. I think we can't accept that date for now, and if there's some sort of an issue, we'll alert the court and counsel.
Okay. That date is already at maximum capacity,
Oh,
but
okay.
but we have to get this done. So I think we will schedule for, and I'm going to schedule, I'm going to put you on my docket for 8:30 on the 19th, but council is putting in their notes that we know you may not be available until 10:30.
That's correct. Yes.
Yeah, so it's still going to be an 8:30 docket setting, understanding that we're looking at 10:30.
Thank you.
All right, we will let Samir know, but thank you for clearing that with us.
Thank you.
All right,
Thank you, Your Honor.
all right.
Morning, Judge. Can we
Morning.
call number 39, Mr. Ortega?
Court calls number 39, People versus Ruben Ortega, 25 CR 2871. Entries.
Good morning, Your Honor. Bree Beasley and Katie Kirk for the people.
Same done, Your Honor. And my co-counsel, she is not present, but that is Nikki Kleiman Moran. Mr. Ortega joins me at the lectern.
All right, this is a status conference. I think Judge Luxon was covering my docket when you all last appeared on January 29th, and set for an 8-day trial. And I guess this conference is for discussing the trial dates that were picked. So I don't know what's going on or why.
I think Judge Luxon was reticent to presume sort of the court's availability maybe for what bleeds into the days of the 20th and 21st. That was my recollection of kind of why he wanted to set the status. Of course, if Ms. Beasley has a different one, she can correct me, but I think he just was sort of the snaking of the trial into different weeks. He wanted to make sure that that was okay with Your Honor in setting it for the days that we picked.
And if I might just supplement, counsel's correct. I think the real issue is whether or not Your Honor would be keeping your docket during the first week of trial. When we were setting this for trial, defense counsel's schedules prevented us from scheduling it any earlier, and Mr. Ortega is not willing to waive speedy trial. Ms. Kirk is actually not available the second week. And so we were in a position, if the court was able to transfer docket during the first week and not scheduling us into the following week, that we could keep that trial date. But if the court cannot accommodate, and understandably so, that we would need to be addressing a new trial date. And because of the defendant's maintaining that he does not want to waive speedy trial, and because his counsel could not accept an earlier date, we would need to have the court make a finding about extending speedy trial under 18-1405 and make findings about that at this time.
And why are we picking the jury on the Friday?
Because this is a multi-victim sexual assault case, and we are, I think, both going to be requesting a questionnaire in this case. We had requested, if it was possible with this court's calendar, to do that on Fridays. That's typically what works easier with an expanded panel.
Well, how many people do we, my notes don't tell me how many jurors we're picking, or what our pool is.
I believe that we had talked about 150.
Oh, okay, then we do have to do a Friday. All right, well, I mean, if you all think it's going to take 8 days, what choices do we have, right?
I think.
So, I mean, and do I have docket coverage? No. Will I? Hopefully.
Okay.
And I know that this impresses upon the court, and we don't mean to put you in a precarious position. When we were looking at setting this current trial so close to speedy, Ms. Kirk and I are uncomfortable with that, and we would normally insist on an extra 30 days of speedy trial to facilitate some wiggle room. She is unavailable the following week, and so we find ourselves in a position of not being able to accept the currently set date if it does go into that next week. And so if we do need to take into consideration the court's docket, we need to ask for continuance in order to allow both prosecution counsel to be present. And that's why we would then be looking at the court making a judicial determination under 18-1-405 to extend trial in order to preserve the defendant's right to effective assistance of counsel in balance with his right to a speedy trial.
All right, well, so I was not with you all when dates were cleared and Judge Luxon was trying to, understand my calendar. So I'll start with this. March 30th.
Unavailable.
Why is that?
We are set. I have a sex assault trial that's scheduled that entire week in 5B. I believe Ms. Clyman Moran also might be set that week.
So March 30th doesn't work for defense?
Correct.
Sir, you have co-counsel. Is she available?
April 3rd? And I'm sorry, because I was originally I just gave you a Monday date, but now I realize if we have 150, I need to be giving you Friday dates. So April 3rd.
Still in that sex assault trial in 5B.
Co-counsel.
And Your Honor, I also will flag that Mr. Ortega just proceeded to arraignment last week on the 29th. So we do need to also accommodate when we're setting the trial, litigating any motions. I know that defense is intending to file a motion to sever and some other potentially more complicated legal.
Okay, well, I need to go through all of my dates so that we can try to find a date that works for defense counsel. So I'm
Understood.
Understood. Thank you, Your Honor.
starting at the beginning. April 10th.
Unavailable. I've got back-to-back trial weeks.
April 17th.
It looks like Ms. Clyman Moran is unavailable.
We don't need her.
April 24th.
Unavailable. I start a 3-day trial the 27th.
Unacceptable.
And Ms. Clyman Moran starts a 5-day trial the 27th.
May 8th.
Ms. Clyman Moran is out of state.
May 29th.
Ms. Clyman Moran has a Friday start on a case that, if I'm reading her notes correctly, proceeds through June 12th.
All right, so May 29th does not work for the defense.
Correct.
June 5th.
Ms. Clyman Moran is in that same trial.
June 12th.
Ms. Clyman Moran is wrapping up that same trial.
June 19th is the holiday. June 26th.
I have a 5-day setting. Ms. Clyman Moran also would be in the
Contempt of
middle of a
court.
2-week trial setting.
July 3rd is the holiday, so we can't set it then. And then we're set to begin on July 10th.
And that's when we are set, yes.
All right. And the problem with July 10th, as I understand it, is the people are not available. Is that correct?
Your Honor, the people are available to start trial on the 10th and go through the week of the 17th. However, Ms. Kirk is not available the following week on the 20th and the 21st, which I believe we've set into on the off chance that the court, or on the chance that the court could not transfer the docket. So we can keep that week if we have that full week of the, I just closed my,
The
15th.
17th.
The
You
17th.
just need me to get rid of my
correct.
dockets on the 16th and 17th.
Yes.
All right. Well, there we are. So,
Cool.
Judge just
all right,
didn't-
so it's really not an 8-day trial. It's a 6-day trial.
yes,
Okay, so I'm going to take off the 20th and 21st.
wonderful.
I mean, I'm
Thank you.
going to remove those from the docket.
Thank you. Judge Luxon just didn't want to make any assumptions about your docket.
Well, that's why there are 10 of us. So,
Thank you.
Judges, there's just one other matter on the defense side of things.
Now I just found out there's 10 of them. I think I can get 7 of them. That means there's 3. There are 3 judges that don't stream in Denver I can't get.
For the motions hearing date right now, we are set on the 27th.
of
Again,
March.
of March, yes. Looking at Ms. Kleiman and Miranda and I's sort of respective calendars, was hoping to move that to either April 17th or 24th.
Judge Eric Johnson is one of them. 4G. Although there's been this lady in 4G lately. I haven't seen Eric in a while.
I can't do that. I'm picking a jury on the 17th. And I'm in the, I'll be in trial on the 24th.
Okay.
So I'll leave it April 20, or I'll leave it March 27th.
Is April 10th just as a backup? Is that something that's doable or not?
April 10th is doable.
Okay, well, I'll accept that. That's still not great, but it's better than the current setting, if that
Okay.
works for the people.
Can the people do April 10th in the afternoon?
I believe so. Yes, we can.
Okay, we will change, well, right now we have dispo and motion set at the same time. Do you want to keep that way, or do you want to leave the dispo on the 27th and then do motions on the 10th?
I think it makes sense to just keep it the way that we have it, is setting both dispo and motions on the same date.
Okay, so dispo and motions will be changed to April 10th at 1:30 PM.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you.
This is Mr. Cook. He is number 13 on the docket.
The court calls number 13 on the docket, People versus Nicholas Cook, 25 CR 5603, entries.
Juan Silva on behalf of the people. Wyatt Pless on behalf of Mr. Cook, who is present and out of custody.
All right, we are set for a sentencing in this matter. There was a PSI that was filed with the court on February 5th. Any updates or corrections to that?
Yeah, I got you. Your Honor, a couple from the defense. This is kind of related to the exhibits that I submitted. I know on page 8 that the PSI indicates that they don't have any records of his currently receiving Suboxone. I know in one of the exhibits I submitted was a prescription for Suboxone that was filled, I think, the day after his.
Oh, I'm sorry. I did not see your sentencing memorandum.
It's
Oh, because it got
It's-
filed at 9:00 last night.
right. It's really a memo, and then there's 3 exhibits. The exhibits are pretty self-explanatory.
All right, let me look at them.
Okay.
Okay, all right. Sorry. I'm looking at your exhibits.
Okay. Just pulling them up. I know the first one is Suboxone, well, buprenorphine, which naloxone, which is essentially Suboxone. That was filled on the 19th, and then gabapentin, those were also filled on the 19th. My understanding is he's receiving that medicated assistance treatment through Magnolia House currently. And regarding his living, I know on page 9 under residential, it notes that he resides at 1275 Corona Street, essentially caretaking for Christopher Camp. That was correct on December 31st. However, in mid-January, Mr. Cook did check in to Ananeo, which is sober living and housing, and I have provided the contract that he signed. That is the third exhibit.
That was on January 15th.
Yes, Your Honor. He checked in on that on his own volition.
All right.
And just regarding his substance use history, there's no question that he obviously has a history of a substance use disorder. I think some of the fine details of what probation reported, I think some of the timelines may be a little bit different, but I don't really want to belabor the point because there's really no dispute the overall substance use history. So I don't want to take any time away from sentencing and belabor that.
All right. People have any corrections or changes?
No, Your Honor.
All right. I will first hear from you, Mr. Pless.
Yes, Your Honor. Mr. Cook, he did plead guilty to assault 3 and to a DUI second, both misdemeanors. Under the DUI second statute, Mr. Cook has to do a term of probation. We are asking the court to, and 10 days, a minimum of 10 days incarceration. It can be done, I believe, in home detention or work release. Under the statute, he is entitled to his credit that he has served on this case. Essentially, I'm asking the court, and what I think is appropriate for Mr. Cook is to grant him time for that he was in custody pre-trial, or pre-plea. He was in custody for 78 days, and sentence him to a term of probation. I think that makes sense for Mr. Cook for multiple reasons. Should he have to complete a further jail sentence, he'll lose his sober place at Ananeo and the sober living and the stability that he's proactively sought for himself. Part of what, and this is reflected in the PSI, is that he's attempting to get his identification card so that he can get more stable full-time employment. Should he be sentenced to a further term of incarceration, that pushes it out and it interrupts the treatment that Mr. Cook has proactively engaged in. As I said, he did serve 78 days in custody, and then the court authorized a PR bond once he pled guilty in this case. When he was released, he was proactive. He realized that his place of living would not further his goals of treatment and sobriety, and so he checked into Ananeo. Ananeo, they do drug test him. They provide classes. It's a pretty structured way of life. He has a curfew of essentially 6 or 6:30, which is when he has to come back and attend some classes. I know they also have some responsibilities. So it's really a structured environment that gives Mr. Cook really the best shot at keeping and maintaining his sobriety. He is doing relapse prevention and coping mechanisms. Just regarding, I think just a little bit of Mr. Cook's history is important here. As reflected in the PSI, he lived with his mother until he was 12, and then lived with his father until he was 16, and then was on his own. I know his both family members both his parents have a history of substance use, and I think that history kind of helps to explain Mr. Cook's criminal history and the place that he finds himself in now. I think his story is a common one of when he was on his own, began working out, taking Vicodin for pain relief after working out. That became too expensive, so he moved on to heroin and fentanyl. The people he was dating were doing other drugs. So I think we see a familiar story of
Yep,
how Mr.
that's a familiar story. Exercise too much, so you need Vicodin. And then that's too expensive, so you go to heroin, which is cheap. Yep, I see that.
Cook found himself here and found himself as an addict, but that is not the person that Mr. Cook is today. He is taking seriously his sobriety. I did talk to him multiple days extensively about what he is doing and how seriously he is taking this. He does note that he has future plans. He wants to keep and maintain a full-time job. He wants to start a family. He really wants to, at the age of 36, he wants to live as long as he can and be a productive member of society. And should he get a probationary sentence here and no further jail, I believe that sets him up for success and ultimately is safer for him and safer for the community rather than interrupting that treatment with a further jail sentence. For those reasons, we ask to give him credit for the time that he has spent in custody, sentence him to a term of probation.
For the people.
Thank you, Your Honor. The court may recall that the reason he was given a PR bond, we put it on the record, was for the defendant to show how he would do with his sobriety. The court saw from the PSI that upon being tested, he tested positive for fentanyl and marijuana, which goes against the basis for why we gave him the PR bond to begin with, to see if he could actually comply. Based upon what he's pled to in those two sentences running concurrent, the people are going to be asking through the DUI a 6-month Denver County jail sentence and a 3-year term of probation to run concurrent with the third-degree assault case. Main reason being, Your Honor, I see this as a case that involves 3 different fact patterns, we'll call it, with at least three different bad decisions. One, he's driving a vehicle, and one thing the court did not have information for that we had just received was the tox report. I'm happy to bring it up to the court if the court wishes, but in his system, and I did provide a copy to defense, he had methamphetamine, amphetamine, and 3 different versions of fentanyl. And I'm happy to provide it to the court. That's what he was driving the vehicle with. And when he's passed out, the second bad decision is him trying to gain access to a home that he did not have permission to be in, reason the police were called to begin with. And then the third being that he spit in the face of the paramedic who was providing him Narcan in order for him to not overdose, hopefully.
What an
So with all that
asshole.
in mind and the fact that he did come back at a risk level maximum, and on his person, or at least in the vehicle, he had about 4 grams of meth combined. The people do believe a jail sentence is necessary. We've seen that this defendant is not capable of monitoring or supervising his own behaviors. He does have those 3 prior felonies and the other misdemeanors. So I am asking for that type of sentence, and there is no restitution.
All right, Mr. Cook, as part of sentencing, you have the right to make a statement to the court. You're not required to. I won't hold it against you if you don't, but if you would like to make a statement, now is your opportunity. Would you?
Yes, Your Honor.
Okay, pull that microphone up to you, please.
Your Honor, I know with the PR bond, you guys told me to maintain sobriety. The living situation that I was in wasn't healthy and I wasn't able to maintain it there. So I took it upon myself to check into a sober living and a more structured environment where I would be able to be successful on probation. At Ananejo, I have to be back every day at 6 p.m. to do classes. I'm doing everything I can. I got a job at WS Barricade waiting for me. Like I said, it took a little bit to get the bed, but I have it now and everything's set up for the future. I'm sober. I can provide UAs, everything. And I know my past has an extensive use of drug history. I lost my girlfriend of 6 years when I was in prison. I lost my best friend. And quite frankly, I'm done with it. I'm 36 years old and it's time, for me to start a career and build a life. And Ananejo is awesome. It's a structured environment and everyone's great. Like I said, I take a class every morning at 8:45 and 6. And yes, I will be one of the few that probably is successful with my sobriety and
Oh,
life.
come on, dude.
Mr. Plus, do you have those UA's results from his time at Ananao?
Your Honor, I have a UA result that sorry, one moment. I do have a UA result that he emailed me from Ananao. I'm happy to email that to the court and Mr. Silva. You know, candidly, there is no date on this UA. I trust that it is from Ananao. He sent it to me, and it does.
We have to take one at least every week. And then there's random rapid results ones as well. So
It does reflect negative, except for one buprenorphine, which is essentially Suboxone that's prescribed. Happy to email that to the court in the district attorney's office right now if you would like it.
As long as, has the district attorney seen it?
No, I can show it to him right now.
I can show you this screenshot that this guy sent me.
How do we know
Totally
it's
legit.
or for this defendant? Well, he sent it to me. It's from.
because the other one has my name on
I
it.
do know, and
Yeah.
if they test positive, No, but I mean, I don't know who it's for. Does it have his name? Does it have any of that information? Right. So, Your Honor, the only thing I'll say is, and obviously
other one has
counsel
my
is
name.
working off of what's provided to him. It's literally a screenshot of results, but there's no name,
There is-
doesn't show the facility. I'm just letting the court know what's been shown to me since I did not see it ahead of time.
I found one with his name on it, actually.
It's written in crayon.
There. You have the dates of when it was done?
From the 30th.
No, you're only working with what you have. So, Your Honor, well, again, what was provided to counsel, what I see now, it does have his name, but it doesn't have dates. It doesn't have a lot of information. It's just a screenshot. And obviously counsel's only working with what he has.
All right. The court's considered all the arguments of counsel. Mr. Cook's statement, the enrollment in Ananao, use of, the prescriptions that were provided, the UA result that was provided. The issue that the court fundamentally has, though, is that it appears to the court that, like many people that struggle with addiction, Mr. Cook has trouble being honest about his use. The court does note that there was a pre-sentence urine screen that was positive for fentanyl, but Mr. Cook denied. He had no idea how he could have tested positive for fentanyl.
Oh, you
but
mean he
now
lied?
is acknowledging that he was using before his enrollment at Ananao. There was also conflicting information that he gave regarding where he was receiving treatment, and when probation tried to verify it, it was inaccurate. So
He lied again?
the court hopes that the last 4 weeks spent at Ananao will help Mr. Cook with his sobriety journey, but I do find that it is appropriate to sentence Mr. Cook to 6 months in county jail on both counts to run concurrent. He will get credit for 78 days, pre-sentence confinement credit on both. There will be a 3-year term of probation on the DUI.
Can I say something, Your Honor?
You may, just a minute. The court will waive waivable fines, fees, and costs except for probation fees. There is no restitution. Mr. Pless, would you like me to hear from Mr. Cook?
Yes, Your Honor.
Okay, Mr. Cook?
Your Honor, I think it was a misunderstanding with the pretrial services. Independence House was where I was taking my UAs at, and Magnolia Health Clinic, I've been with them since right when I got out of jail, and there was no reason I would lie about it. And the confusion with the test for the fentanyl was because I took a UA earlier that day at Magnolia Health Clinic, and it only came up positive for THC, and that's why there was a misunderstanding. I'm sure like the levels were super low, and I wasn't trying to be dishonest. I think one of the reasons why my PSI reflects a substantial history is because of the fact that I was completely honest with my history. And with that being said, like all my
Your Honor.
property at Ananejo is there and stuff, and I don't really have family here anymore. So if there's any way we could, if I could be reprimanded like tomorrow or anything like that, I'm completely willing to keep the ankle monitor on so I can at least get my stuff to a stable place, because I'm gonna lose everything that I've built if I just go to jail right now.
And Your Honor, this all happened because I was too honest. That's why this all happened, Your Honor.
Well, do the people have a position? Well, do the people have a position on remanding tomorrow?
Your Honor, I generally object only because we are set for sentencing today. On the second DUI, there is mandatory jail, so he should have had an expectation that he'd be taken into custody. I'll defer to Your Honor. Obviously, my concern is he flees or doesn't come back, and then we just have this outstanding for however long it takes.
Ankle monitor.
Yeah.
And Mr. Cook is currently on an ankle monitor. I mean, he has a signed contract from Ananeo, so I don't think there's any question that his stuff is at Ananeo.
All right, the court will order you to return tomorrow at 9 a.m. to be remanded. He is on a PR bond, so I don't think we have to deal with surety at all, but I do need you back here at 9.
Here or the jail?
You'll come to the window up here and you'll report, and then we'll have you taken into custody then. All right, anything further?
Not for the people.
Not from the defense.
All right.
Just bring yourself on and text me.
All right. I wasn't going to, but I'm going to show next a video that I put on Court Disorder, my video channel today. I liked it, so I'm going to show it again here.
And the moment in which we live, that threats of contacting ICE do constitute threats of assault or threatened bodily injury, and could constitute a threat of imminent danger to you and or your child. Okay.
Yeah.
All right.
And I do have to pause this every once in a while or I'll get nailed for reusing my own content.
Ms. Rodriguez Castro, you are requesting a protection order in this matter. And so what I am going to do is have you testify to the specific reasons you're requesting this protection order, okay? And in order to do that, I would have to place you under oath to tell the truth.
Okay, get ready. Her accent is delicious. It's amazing.
And if you're ready to proceed, we'll do that here now. Are you ready? All right, perfect. If you raise your right hand, do you solemnly swear under penalty of law that the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
I swear, yes.
Perfect. And can you please state your full name for the court record?
Rosa Vicenta Rodriguez Castro.
All right, Ms. Rodriguez Castro, can you please tell me specifics, not general terms, what happened to cause you to file a request for a protection order?
Okay. I'm having, Okay. So specific, it's that she's putting my daughter into this situation. She's defamating me, saying that.
Okay, hold on. You say she, I'm gonna have you name a person.
Yeah,
And then I
Sonia
want you to
James.
be specific about what's happened with her statements or actions to you. You're the one sitting here.
Okay, to me. The statements are that she didn't tell
She,
me.
who is she?
Sonia James
Okay, go ahead.
didn't tell me straight. She told to my child's dad that I'm abusing my daughter. Also, she's been treating us in the apartment by saying that we are illegals. That we are illegals in the apartment, and she is gonna call the ICE.
And why is she in the apartment, same apartment that you're in?
Because I am renting the other bedroom to her, and the issues start.
Are you
to
roommates
Sonia
right now?
James.
So you're roommates right now?
Yes. So
Okay, so who did she tell you that you were abusing your daughter?
Kevin Aponte is my daughter's dad.
Okay, and when did she do that?
On Friday. On
Okay.
Friday, after I left her 30 days to live, which was on January 9th, she started escalating the problem, saying that first she went to the office, saying that we are illegals, that she's gonna call ICE, asking for the contract.
When did she go to the office saying you were illegals?
She went by the 30th of January. By the 30th of January, because the assistant told me what she did.
Okay,
She also was asking for the list, but she's not on the list of the apartment where we live. She's
Okay.
not on the list. Yeah, I gave her 30 days notice because she didn't pay me on time, and I was really struggling on money.
Okay.
When I gave her 30 days, she started telling that she got sick because my place doesn't have living conditions, which is fake. She mentioned that, and she told me also I have a record where I tell her, okay, if you say it's not good in living conditions, leave my apartment. You have 30 days. I had a video where she says, okay, I'm gonna leave in 30 days. She didn't leave, but she's been going to the office to trying to ask for the list. My daughter's dad was trying to be an intermediate, like, hey, this is the space for my daughter and her mom. What do you need to leave? Because I have a demand of compliance that if she doesn't leave, everyone is leaving. She said she has to pay my hotel in February or I move in March 1st, but she needs to leave by this month. Since then, they start talking, and since then, she starts sending messages to my daughter's dad, saying that my house is a toxic house. That I have the messages that she sent it to my daughter's dad, saying that I'm screaming, I'm taking all the kitchen stuff, I'm throwing all the kitchen stuff in my apartment, which is fake. She's putting like I'm a bad mother. She's putting she's interfering in my parenting confidence, Like, yeah.
Anything else?
Yeah, and the other thing, it's about ICE. I have my visitor, which is my best friend, who helps me for 3 months taking care of my daughter. Before she moves to my place, I told her my auntie might come to help me with my daughter. But my auntie didn't come, and I told her my best friend is coming. So my best friend is legal with a tourist visa. She's here until March. But she started saying, like, in front of my best friend, oh, I'm going to call the ICE because this person is here watching the daughter, and give the Buffalo address. So she's kind of threatening to my visitor. And when she went to the office too, also, we got a police officer coming to our apartment because we got a little confrontation, and I didn't want to escalate. So I called the police. Hey, help me because I want her to be out by the 6th or I will lose my apartment. I don't want to lose my apartment. She's not in the list. She didn't even pay me February rent. So I'm still struggling on rent. And the police told me I cannot do anything. But I told him, I'm afraid because she's mentioning ICE. And she was like, when did I mention? We got a confrontation in front of the police, and also in front of the police, she says, I could call and make them to deport you. That's when the police.
And how many times did she do that?
She did. I feel one was in front of my visitor, second was in front of the police officer, and the third one was in the with assistant, because she told me, because she was scared too, because she started.
And are those 3 times happened within the last how many days?
And the first time was after I gave her the 30 days notice. I can tell January
something?
15. The second was when I put her when I gave her the demand of the plan.
Okay.
Sorry, I have to pause it or I'm going to get in trouble with YouTube. I have to talk a little bit in between. But her accent is like sucking me in. I just want her to talk to me all day long. She definitely sounds credible. Abso-freaking-lutely she does.
All right. Then Ms. Rodriguez Castro, you are here requesting a temporary protection order, and what follows with that is
Monica, you wish you knew how to speak Spanish? Wait till you see my next video. It's coming after this.
permanent protection order hearing. This court can grant a temporary protection order to prevent assaults and threaten bodily harm, to prevent stalking, if those threats occur such that imminent danger may exist to you, Ms. Rodriguez Castro. You've told me a number of things. You've told me that Ms. James, who is currently a roommate, has contacted the father of your child, stating that you are abusing your child and you have a toxic house. You've also, more importantly, you've also told me that on 3 occasions, beginning in around January 15, 2026, Ms. James has threatened to contact ICE on 3 separate occasions, which causes you to be afraid and causes you distress. The court finds in this environment and the moment in which we live that threats of contacting ICE do constitute threats of assault or threatened bodily injury, and could constitute a threat of imminent danger to you and or your child. I do find that there are grounds, sufficient grounds to establish the necessity of a temporary protection order, and I will grant your request. Until this is served on Ms. James, the temporary protection order is not in effect. It only becomes in effect when the temporary protection order is served personally on Ms. James. So what you will want to do now is you'll want to head to the court, back to the court clerk's window. They are going to give you the temporary protection order with a court date and time. That will be your permanent protection order hearing. You'll need to take that to the sheriff's department and have the sheriff's department personally serve those documents on Ms. James. When you come back for the permanent protection order hearing, if you have any documents you wish to submit it as exhibits, you need 3 copies of those documents. So you need printed 3 copies of those documents. If anyone, you want anyone to testify, or you want somebody to testify to something they heard directly from her, but you didn't, or they wrote down in a document, you need to have that third party come in person to testify. Do you have any questions about that?
No, I'm just worried about my daughter. I'm just worried about my daughter. She mentioned that my apartment has hold. I have broken furniture, which is fake. I'm just wondering, like, since she's mentioning to my daughter's child that I have my holes on the door, I don't have it. I already recorded, but I'm worried like she could do something
Sure.
against me.
Just keep recording, you did the right thing to record what's in your apartment so that you
Yeah,
can
and I just
substantiate
want to
that,
protect my
okay?
daughter, my parenting, because I don't want to lose my daughter. I love her. If someone hears that I'm
I
abusing.
understand. And that makes perfect sense to me. Let me see, I will sign this protection order.
Okay, that's good enough. Now, you wanted to learn how to speak Spanish? Here we go. Let's do this. It's a very short clip, but you do have to wait till the end until you learn some choice Spanish words.
People versus Gonzalez Martinez. If I can have entries of appearances, please, starting with the people.
Colleen Gray on behalf of the people.
Good afternoon, Your Honor. Becky Briggs on behalf of the defense.
Se convocó la causa 24CR261 González Martínez. Se presentó la fiscal Bram. Se presentó la defensora Briggs. The interpreter is Santiago Páez, 22080.
Thank you, Mr. Pies. Appreciate you being here as well. We're set for a case management conference this afternoon.
Yes, Judge, and we have not filed any motions that require an evidentiary hearing. I would ask to move this to the pretrial readiness in April.
Hoy tenemos una audiencia para gestión del caso. Sí, señoría, no se presentaron pedimentos que requieran pruebas. Entonces pedimos que se fije la causa para abril.
Okay, and you said there's not any testimonial motions filed. I don't see any motions though, so I just want to make sure that there's.
Correct,
Okay,
Your Honor.
perfect. Thank you.
Dijo pruebas, pedimentos probatorios, pero no veo ningún tipo de pedimento. Es correcto, señorita.
Okay, I guess anything from the people? All right, we'll continue this then to pretrial readiness on April 24th at 8:30.
La fiscalía se aplaza hasta el 24 de abril a las 8:30. Gracias.
Thank you, Ms.
Se
Briggs.
me aplaza, no voy a permitir que se me aplace la corte tan mucho tiempo. No puedo permitir eso. Yo tengo 1 año y 2 meses acá. No lo voy a permitir. Que se me haga la corte lo más pronto posible. Tengo 1 año y 2 meses aquí encerrado.
I cannot allow that. I've been locked up for 1 year and 2 months now. I've been locked up for 1 year and 2 months. I need this to be faster than that.
I hear you, Mr. Gonzalez Martinez. We are set for trial that will take place in May.
Le escucho, señor González Martínez. Usted tiene un juicio programado ya para mayo,
May 5th.
5 de mayo.
Necesito que presenten las pruebas porque hay muchas cosas que nadie sabe y me están haciendo una audiencia virtual para no hacerla presencial. Necesito que mi corte sea presencial porque hay muchas cosas que no saben. Hay muchas cosas que no saben y no voy a seguir permitiendo que sucedan estas cosas. ¿Ok?
Yes, I need please that instead of virtual that I be brought in person because there's a lot of evidence that is not coming out. There's a lot of things that have happened that are not of which there's no knowledge. Please.
Okay, we can I'll grant that request to have Mr. Gonzalez Martin present in person at the next court date.
Muy bien, se le otorga la solicitud, señor González Martínez, de que usted comparezca en persona en la próxima fecha.
All right. Thank you. We'll be.
Thank you, Your Honor.
Mr. Gonzalez Martinez's case. Thank you.
Se levanta sesión en el caso.
Oh, fuck. Beach.
Here you go, Monica. Just watch that over and over and over and over again. And you'll learn how to speak Spanish happily.
Yes, I am, Your Honor.
Yes, Your Honor, we are expecting the victim to be present today. She wanted to modify
Yes, I-
the MPO. Your Honor, she has notified us that she does not want to make a statement today, but she would like the protection order modified to full contact.
Well, the court, this is a brand new case. It's only 10 days old. Mr. David.
Oh, yeah.
you're
Okay.
not-
So in this courtroom, her microphone kept cutting I should say this sound, kept cutting off like after like 3 or 4 words, okay? And it's like that for the beginning, but it's not like that for the good part. This is also a very short clip. And this choppiness stops soon.
Not represented, anything you say can be used against you. I'm assuming that you would join in the request to have the protection order less restrictive and to get rid of it. So I'm making that assumption on your behalf that you would want that. The court has reviewed the affidavit in the case. I've also reviewed the pretrial report, which lists the criminal history, which isn't particularly lengthy, but the court is aware that Mr. David is currently on probation out of Denver. And so I've familiar with that charge in that case and some of the circumstances. It's not DV. The court does still have some concern as it relates to general community safety and the circumstances here. The court also considers how I treat these types of domestic violence cases and the approach I take with them. In review of the current mandatory protection order that Magistrate Solomon issued, the court notes that you are able to have contact with both Isa and the child, who is first initial U and then shares the last name of each of the parents, presumably. I'm just not saying her name because we live stream. That there is contact in person in public places. So anywhere I can be, certainly in the courthouse, you can have contact and you can have communication electronically or otherwise. The restriction is that you can't return to the home. So the request of Miss Isa today would be to remove that so you could return home. And I appreciate that request. Quite frankly, whether she came in here and asked me in person or not, the court believes there needs to be a further cooling off period. So I'm not going to change the protection order today. You can still have that contact in public places. You can still communicate, but I'm not going to allow a return home given everything the court's taken into consideration.
Because you think I'm a bad father?
That's not what I said, sir.
Get cheated on in my own home.
I'd be
I take
quiet.
care of my bill.
I'd be quiet because anything you say can be used against you. The court has looked
He doesn't have anger issues, Judge. He just proved it.
at this. I will reconsider it in the future, but after 10 days, the court is going to be consistent with how I handle these cases, and I'm not going to modify it further today. It can be further addressed at the next court date with more of a cooling off period, and then anything else if a defense lawyer wants me to consider further. You have your next court date. If you want Ms. Gann's information to find out what the offer is when she makes one, you can do that. And like I said, and I want this to be clear, quite frankly, that even if the listed victim had come in here and asked the court and said she felt totally fine with you coming home, I would not have done anything different. I'm being consistent. That's my choice and my decision. It's not hers. And I appreciate that these situations can be volatile sometimes. And so I just want to make that clear to you.
Sounds great, Your Honor.
Make sure you don't leave without filling out that affidavit.
Sounds great, Your Honor.
Why don't you can just have a seat at that table right there to fill it out and then give it to Mr. Benegas when you're done. That concludes that matter.
But he got cheated
we
on
have
in his
a-
home. You don't understand. He wants to see her again because they're very much in love. They're soulmates. But he's still angry, I think. All right, guys. Thank you so much for coming out today. I appreciate it. I do. Last night was a great stream. This was a great stream. I'll have more tomorrow. Tomorrow is Tuesday. Oh. Okay, let's do something. Let's do Taco Tuesday at 4:30 in the morning. Let's make tacos and have them tomorrow morning for the live stream. Yes, but I'm not going to eat on camera, but I am going to eat tacos tomorrow morning during my live stream because 4:30 to me is my work day. It's not 4:30 a.m. for most normal people. You be safe too. The roads are ice right now. So if you're going outside, don't. Just don't. Call in sick. Bye, guys. Love you. Thank you so much. See ya.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.